2011 has been called to order. The first thing that we have on the agenda is future agenda items. Does anybody have a listing for future agenda items? Commissioner Nocita.
Thank you, Doug. I have an agenda item I'd like to start a discussion on, which one of our citizens and planning commissioner, Denise McGriff, has been raising before the Citizen Involvement Council, the McLaughlin Neighborhood Association, and the Planning Commission also, which is doing a community visioning process for our urban renewal area, similar to what they did with Beaverton, with the Beaverton Community Vision. And I chatted with her on the phone a couple times about this, and she said she's having a very good discussion about it. And I wanted to bring that the discussion at the city commission level and on the urban renewal commission level both, because of course one of the issues is funding. And while we're still wrapping up our budgeting process, I've been kind of thinking about how a community vision like this could be funded, maybe with a joint funding from both the city budget and the urban renewal budget. Okay. I gave a call to a couple of folks, one of whom was a guy named Jason Robertson, who is actually the consultant that is helping Beaverton out with their community visioning. And he said it varies, he gave me a ballpark price depending on the city, the type of situation the consultants are confronting, from anywhere from 50,000 to 200,000, which is kind of a wide range. I didn't make the urban renewal budget committee meeting, but I watched it on TV, and I think there was a discussion on discretionary funds, and some of it was unsettled, if I recall the discussion. But I think with some of the wiggle room with that discretionary funding on the urban renewal budget, and the city commission budget, which is of course much larger, I'd like to advance that, particularly in light of the visioning that we want to see and master planning process for the mill, and what the community's vision is for the mill. So I'd like to just put that on the table. I don't know if there's anything to do about it tonight. Maybe we could have an agenda item during next week's commission meeting and chat about it. I don't know if that's something, how full our commission meeting is next week. But it's kind of the timeline I see on this, making a decision about it is, just we have to have a budget adopted by the fiscal year beginning July 1st, and I think, the next.
Well, I would suggest that
now we could probably have a pretty good discussion.
it'd probably be a little bit more helpful to staff if, in fact, we schedule it in the study session as opposed to the next commission meeting, and have some basis to discuss it at that point, and then perhaps put it on a subsequent commission meeting. If that's
I mean, like the June work session?
That would be the June work session.
If I might add, if the funding, for example, were to come from the discretionary money in urban renewal, it won't change. It wouldn't upset the rest of our budget operationally at the city, because every dollar in there is kind of accounted for. So if you make a change, then we have to change something else. In other words, take something out of that budget, we can reallocate, but we have to cut something somewhere. And so it's a little cleaner if you look at the discretionary funds, and just so you don't feel pressured by the timeline on the adoption of the budget, even if that budget is adopted, the urban renewal budget, those discretionary funds will still have to be discussed by you, so you will have a chance to fine-tune that more if you want to for that kind of a process. We also have, I think, a handful of other plans, master plans and so forth, that probably are due for updates. So you want to consider that in the whole mix. But I think that the urban renewal funding is probably at least for us, it's easy to do.
David, I'd also maybe I know we budgeted $100,000 for Blue Heron, And when you originally worked with staff to develop that number, Blue Heron's obviously really hard to,
spend 25 million.
But I'm just wondering if in developing that number, there was thought given to master planning or visioning for the site.
Yeah, we didn't do any formal, we didn't get quotes or anything, but we were just estimating that depending on what happened down there, the planning, that's why that number was as high as it is, because if there was any long-term planning, we also knew that things like right-of-way acquisition, public access, and even the bankruptcy proceedings were all going to be pretty expensive, so I think 100,000 is pretty conservative estimate.
Okay, thanks.
Anybody with another? Yes.
I would like to bring up again the rezoning of the public works site. I don't see any reason to not start that process at this time. And given this is going to take 6 months or whatever, I think that we need to start moving on it. Did that?
Isn't that on to the June work session?
Yes, we have a public works site discussion and a request for rezoning on the June 7th work session.
Okay, thank you.
But could you, how many items do we have? We have this additional one recommended.
June 7th,
Yeah.
1, 2, 3 at the moment, and then if Commissioner Messitas is added, that would be 4. The one item on the public works could take the whole evening, so.
Well, I'd like to recommend one, but maybe not that time sensitive. Maybe it can be in July. But dealing with school zoning, you have the school zoning marked. Some places it's right on the property line. Some places it's somewhat before the property line of the school. But in certain areas, and specifically it's Mount Pleasant, where you have a major complicated intersection, signalized intersection that's there. Namely, you've got Warner Parrott, Warner Milne, you've got Central Point, you've got Lynn, all of those intersecting at essentially the same point. You've got a lot of elementary schools that are crossing at that particular intersection. There was a kid that was almost hit there at that particular intersection. I wonder if we should explore actually starting the school zone slightly before the intersection on the distal part of the intersection of the school zone. So that's something I'd like to have discussed at a work session.
I have another one.
Okay, this would probably not go in June.
I was actually going to propose that we add an executive session at next week's meeting to talk about alternative sites for public works. And I'd also like to talk about library siting. I don't know how far along the process is, but next week? Okay. Could we make that a discussion for both? And the reason I say that is I think there may be some overlap of sites, and I don't want to get into a conflict, and I want to just see where, how discussions of library siting questions would interrelate with discussions of public works siting. So if we could do that jointly at that executive session next week, I'd like to propose some sites, and that's where I think I'm worried. I'm just careful to wanting to avoid, conflicting ambitions.
Yeah, the fact that you're already going to be in an executive session for real estate transactions lawfully anyway, you can do that. It's the discretion of the commission if you want to have that latitude. Your exception is going to be the same. I'll just have different staff there.
Do we have an urban renewal session scheduled for that
We'll
one?
talk about that tomorrow. We do sometime in the next couple of weeks. We're
Okay,
looking at it at a time.
then we'll put the executive session after the commission session.
We were looking at the possibility of a week later for the urban renewal.
Because it's just
Time
getting
crunch.
too overloaded on
Yes,
those
it is.
nights. So we'll talk to you offline tomorrow in our meeting about that.
When you do things, you're talking about a different Wednesday, then I said, you gotta watch for the impact meetings. The impact meetings are on the first and, are on the second and fourth Wednesdays,
Evening?
from 5 to 7.
Oh, okay. Second and fourth Wednesdays.
So it's the commission's prerogative if you want to broaden the topic of your executive session to include public works and library. If you do, then I'll want to make sure I know that so that I can have all the right staff there. Is everyone okay with that?
Yeah. Thank you.
Any others? Okay, with that, we'll go into our discussion items. The first one we've got is for a land use training session, and Mr. Cochran.
Thank you, Mayor. So I think it's been a little while since we've done a land use training presentation. We've presented this to the Planning Commission already, but we thought it'd be good to come back and have a refresher on Land Use 101 from Mr. Sullivan, and then answer any questions or any discussion that the commission would like to have while we have Mr. Sullivan here, as well as myself.
Request to call it Land Use 102, please.
Mr. Wyatt, what do you feel about that?
You're probably
Think you're outvoted, yeah.
Okay, I think I'm going to try to do this in about 20 minutes, and then feel free to ask questions before, during, after, as you go along. Commissioner Nocita has enough land use law under his belt, so he's more than dangerous. What I'd like to do is just give you sort of a broad brush approach to land use and decision making. And I started out with a fairly boring chart that you see in front of you. I always think about this, and I think Commissioner Nocita remembers it from his class, as a big pyramid. I'm just going to go back. The United States Constitution sets our national structures and priorities, and the U.S. Code carries out, from a federal standpoint, those laws. For the most part, these are not big issues for the city in most cases. On occasion, they are. You get a takings claim, you get a First Amendment religious freedom claim, you get maybe a due process claim. But for the most part, the United States Constitution is a backdrop. It's there. I can count on maybe two hands the times that it's really come up seriously before the Commission in the last 25 years. The U.S. Code also doesn't present much of an issue. There are 3 or 4 areas where the feds do engage in land use, besides their own lands. For example, telecommunications or religious freedom. What happened? That's right. There it is. Okay.
William, do you have your phone turned off?
But for the most part, the U.S. Code doesn't enter into it. Really, land use is a state area of interest and expertise. The Oregon Constitution, again, deals with the structure of Oregon government. It's fairly typical, the tripartite system that we have, legislative, executive, and judicial. Under the legislative domain is the passage of statutes, which the executive branch enforces, and the judicial branch interprets. Our statutes set up a fairly complex web of land use requirements. And they're found for cities mostly in Chapter 227, which relates to city planning and zoning. Has been that way since about 1919, when Oregon was one of the first states in the Union to pass enabling legislation for land use. In 1973, I think you all know, we passed Senate Bill 100. Senate Bill 100 set up a state structure for land use. That's found in Chapter
197. If you ever have trouble sleeping, have a look at it. It's delightful. What our state system, though, does is to set up a Land Conservation and Development Commission. You've all heard this as LCDC, with a staff called the Department of Land Conservation and Development, or DLCD, which takes legislative direction and formulates land use policy. On the chart, that policy is in 19 statewide planning goals, and they run the gamut from procedural to very particular substantive goals. The last 5 goals relate to the Willamette River Greenway and the coastal areas, which are not, of course, Oregon City's concerns. But the remainder of them are. There are 2 process goals, 1 and 2 citizen involvement. We've been very brave about saying that we think citizen involvement is important, but in the final analysis, it's a fairly weak system that we have. More of it is found in the procedural rules that the legislature requires of cities and counties, and not much more than an aspirational goal on citizen involvement. That's too bad, but that's unfortunately the way this program has been administered. Goal 2 relates to the process of land use planning, requires an adequate factual base, and Oregon takes the position of about 16 to 18 states in the union that plans must be done, and plans are, as I call it, an impermanent constitution, a constitution that can be changed, but it governs all of our land use regulations and actions. Oregon is very much different from most of the other states in the union on that point. These 19 planning goals often, but not always, have a set of accompanying administrative rules to carry out the fleshing out of what's required in these policies. Since you're not a county, you don't have to deal with goal 3 and 4, farmland and forest land. We don't have the mind-numbing regulations to deal with for those soil areas and for those land use regulations. But we have an analogy in places like Goal 12, which is transportation. We have the Transportation Planning Rule, or TPR. I'm sure you've heard of it, which requires a great deal of work to go into a plan amendment, a zone change on occasion, and individual applications for permits.
That's how Tony overcomes insomnia. Rule 12.
Or takes stiff drinks. These rules then interpret the goals, and they're binding interpretations. We've gone a long way since the original LCDC idea of having policy papers of giving guidance, but not binding guidance, so we could go either way when we came to make the decision. Now the rules are really binding. Most of the action locally, going back to the chart, is in the city comprehensive and other plans, transportation plans, public facility plans, and the like. And then the implementing regulations, subdivision, zoning, and other items that carry out the plans. And if you do the old Dry Bones song, the code is connected to the plan, which is connected with the goals, which are connected with statutes, which are connected with the Constitution. It's all a hierarchical system, and it makes sense. It is not the system that is in play in most of the United States. These are typical ways of decision-making that we put into our code. The type 1 decision is the non-discretionary building permit type decision. You either make it or you don't under the code. So it's either 10 feet or more back as a setback, or it's not. It's either 30 feet in height or it's not. Those decisions don't require a hearing. Type 2 decisions do involve discretion, and they are those kinds that the city has chosen to send out to the neighbors and see if anybody wants a hearing on it. There is some discretion. There's a proposed order And if anybody wants to take it to the next step, they pay $250 and they can take it to a hearing. Okay? Type 3 decisions are decisions that are always hearing decisions. Okay? Usually, in our case, before the Planning Commission, sometimes before the Historic Review Board, and then there's an appeal level after that. Type 4 is the largest amount of discretion. It does require a hearing and almost always involves the City Commission. So when you do a plan amendment in this city, you go through the Planning Commission and the City Commission.
And who are the parties that can initiate plan amendments and zone changes? I know an applicant can, like
Right.
Leona, but can the Planning Commission itself initiate it?
I believe so. Tony knows that. But, it's really just a matter of the ordinance. I can tell you just after looking at it. But normally ordinances allow discretionary bodies such as the Planning Commission or the City Commission to initiate things. Okay. And even if it didn't say you couldn't, you can anyway because you're the ones who run the ordinance. Okay. The kind of notice also will be appropriate to the kind of decision that you have. There's no notice on type 1s because there's no discretion. On type 2, there's notice given to usually it's required by statute to do 100 feet. You can go more than that if you want to locally. Type 3 and 4 also requires that kind of notice. And there's also a discretionary notice that's allowed under statute, which we do, and that is to go to neighborhood associations. And sometimes you can give it to LCDC as a matter of discretion. Whenever you change a plan, you got to give notice to LCDC.
On type 2, I know once I gave some written testimony, but I don't know if that was a part of the hearing. I know it was taken into account. But when you talk about a hearing, you have a type 2. I presume responses from individuals in the neighborhood and so forth can be part of that record.
Yes.
Even though there's not a specific hearing for it.
There's a written record when the notices go out. And then if somebody asks for a hearing, there's an oral hearing. So all of that written stuff is in the record already, plus anything that's given orally.
But that requires a person to
Kick it up to a hearing.
and pay money in the process.
$250. And now,
You waive that,
you
presume.
can waive that for neighborhood organizations. That again is a matter of local discretion. Okay. This is boring too, but it's necessary. The kind of decision making that you make determines the kind of review that you get. You've all heard me talk about quasi-judicial. It's when you focus upon an individual set of circumstances or a property. So when you're doing a conditional use permit or a variance or a single tract zone change, that's probably going to be quasi-judicial. If, however, you were going to replan or rezone the whole city or the McLaughlin neighborhood, that's probably going to be seen as legislative. Now, that makes a difference in the way that you look at the testimony and the way I have to look at it when we hear things and have an obligation to make findings to explain what we do. A legislative decision makes policy, and generally that is constrained only by the Constitution and any statutory laws that are involved. So notice would be a requirement, hearing might be a requirement, and because we've got these statewide planning goals that overhang all that we do, we may have to make findings to show compliance with any applicable goals. Now, findings are normally seen as part of a quasi-judicial process. We make findings in a legislative process, so it makes it easier to defend, because otherwise you have to glean it from the record when you go up on appeal, and that would be my job. Most city attorneys say, let's see findings when we have something that applies state policy so that we explain ourselves easily. A legislative hearing is what I call an all-comers hearing. Everybody stands back to back and comes up to the microphone and gives you their views on policies. It's up to you to distill those views and to make the policy that's consistent with statutory law and the goals. In a legislative setting, you're going to hear from people in the supermarket, on the street, in these chambers, and that's fine. You don't have to disclose ex-party contacts. And we also, in the state view of things, expect you to bring your policy judgments. That's why you're elected. So you bring those to the decision making, and you make policy. So long as it's consistent with statutory and constitutional law, that's fine. And then you look at commonly, you look at some of these type 3s and type 4s on the record that's made before the Planning Commission and take argument. That really is a matter of structure, though, for you to determine. And there's no decision-making timeline, no 120 days that we normally associate with quasi-judicial matters when you make a legislative decision. On the other hand, if you move to the left side of the chart, adjudication focuses on individual persons, properties, or situations, and there the process, or just the nature of the process itself, requires that you explain yourself more fully and that you act more like a judge, a quasi-judge, so you can wear a quasi-robe when you make these decisions. So there's a big statute on point, 197-763, land use attorneys know it by heart, and it sets out the expectations for quasi-judicial hearings. You hear me blather when you have one of those hearings about whether or not you've had any ex-party contacts, whether or not you've had any biases, and I will also explain to the those who are here that the criteria for the decision making are set out in the notice, which is usually at the back of the room. And if anybody wants me to read it, I'll do that. And the general injunction to focus on those criteria, and if you have other criteria that you think are applicable, you've got to raise them at the hearing. Failure to raise an issue with sufficient specificity, what the statute says, to allow the decision makers and other parties to respond to it will preclude an appeal on that criteria to the Oregon Land Use Board of Appeals and to the Circuit Court. Impartial tribunal doesn't mean that you don't have opinions on things. It does mean that you've got to try to be fair to the parties that are before you. You can't let personal bias, as opposed to policy bias, be involved, and you can't have an economic interest in the outcome in any way. Raise it or waive it is what I just explained. If you don't raise it, an issue, and it was in the criteria, then you can't raise it at LUBA for the first time. LUBA reviews appeals on the record. Most of the time, the City Commission reviews appeals on the record. There are occasions in which it does not. And the biggest job for me is to make sure that whatever you decide, I write adequate findings and conclusions that will survive an appeal. And then you also have the 120-day rule that we've got to meet to make a decision from the time the application is deemed complete till all the appeals at the local level are exhausted. Has to be less than 120 days. If it's more than that, then the applicant, and only the applicant, can bring a mandamus proceeding against the city in which the burden of proof is reversed, and the city and anybody who opposes the application have to prove a negative, why the application should not be granted. If we lose, we pay attorney fees. If we win, we get attorney fees. There's one other caution that I didn't put on this, and that is to the applicant, that if they have any objection to any of the conditions of approval that the commission might adopt, they've got to raise it with sufficient specificity, or they can't bring a claim for damages in circuit court. These are the disclosures. I've gone through most of them before. Criteria are here. If you want me to read them, I'll be thrilled to do so. The staff report has to be done 7 days in advance. Tony's always done that. Testimony should be directed to the criteria. If there are others, let us know. Failure to raise it waives the issue at LUBA, and then the caution to the applicant that if you don't raise an objection to a condition, you've waived that, and you have the right to the impartial tribunal. No pre-hearing or ex-parte contacts.
Could you tell me the instances where something gets appealed to LUBA versus the circuit court in land use issues?
Almost never to LUBA if it's a land use decision. The one exception would be a Dolan takings argument, where you have the ability to go either to LUBA or to circuit court. And that's a strategic decision that a developer's attorney would make. If you want money, you go to circuit court. If you want invalidation of the condition, you go to LUBA. In either case, if the developer wins, the developer is entitled to attorney's fees. Okay. This is what the impartial tribunal requirement. This comes back from a case, my case, called Fasano versus Board of County Commissioners of Washington County, 1973, Oregon Supreme Court, and talks about the ex parte issue. You've got to disclose it. And my strategy.
No, that Rocky wasn't even a believer in his father's eye then.
I was just doing a case. The strategy I usually use is complete disclosure, and I normally turn to the audience and ask if there have been any ex parte contacts. Does anybody want to question any of the commissioners on the matter? And almost nobody ever does. But once that's done, you're immunized from that point on, so long as you've told the truth, and there's no issue there. And anybody who has a problem with ex parte contacts or bias has to raise it if they know it at the time of the hearing. You see the actual bias issue there as the second major point. If it's impossible for you to make an unbiased decision, you should step down. Right? But again, it doesn't mean that you haven't a view on policy. If you've got any economic interest in the outcome, you have to step down. And then there's that issue of potential conflict of interest. If my law firm has some interest in a particular issue, and it's not directly on point, but it's there, I've got to reveal it, and then you can go on. But actually, if you're going to get money out of the decision, then you gotta step down.
I think this is probably one of those areas too where we do try and caution. You know, if we realize you're involved in your neighborhood associations and whatnot, and it's hard being an elected official where you get phone calls or you get these emails. So it is important that you realize that, and it's hard if you don't know if something's going to be brought up to you on appeal, or if there's a land use application that is going to come through to you that's a city commission decision, it's a quasi-judicial one. We can certainly assist you if that does arise. But as Ed's saying, just always disclose it. That way we can address it, we can deal with it, and make that decision from there.
I think this is the last slide, and it has to do with public hearing procedures. As I've mentioned, the staff report has to be available 7 days, and we've never had a problem with that here. The applicant usually leads off, even if it's an appeal hearing, because the applicant has the burden, and the applicant gets to go first and last. And there's interested parties. Usually the applicant's side takes the first one, then the opponents, and anybody allied with the opponents. Applicant gets rebuttal. There is, under the statute 197-763, the ability at the initial hearing to require either that the record be left open for 7 days or that the hearing be continued for at least 7 days. After that, it's all discretionary. However, there's another part of that statute which says whenever new evidence is allowed, you must allow for a response. What always freezes my blood is what happens when you're close to 120 days and you've got that. And the answer is you do the best you can. And so we always try to get these appeals to the commission so there's at least a couple of meetings for you to make your decision. And then the last point is the hearing record, and that's largely city recorder and my function to make sure that we know what's in and what's out of the record, because when you get to LUBA, there's always some beef or not about whether something was actually in the record or not. A reference to something doesn't make it part of the record. You really got to physically present the matter before it's in the record. Okay. Yeah, this last thing, public meetings, public records. You all know about public meetings, quorum, a majority of a quorum, and you all know about the Dundee decision that came out of Lane County. I circulated it. That case was settled, so it will not go up to the Court of Appeals. So we won't have any better idea of what communicating by email or through assistance means. Please don't. Any meeting is presumptively open to the public. You know that we go through a drawn-out process where we cite the statute if it's going to be an executive session, and we try to stick with that when we're in executive session. There's got to be notice appropriate to the circumstances. There are emergency circumstances where you give the best notice you can, but normally it's a 24-hour requirement. You got to take minutes of regular meetings. The tape will do for the executive session, and enforcement is through a process by which you can get attorney's fees as a bounty hunt in the event that a public body violates the open meetings law. Public records, again, everything is presumptively public if it's in the public hands, and I know that includes work-related, city-related emails. They're generally available to the public. There are exceptions, and there are 2 statutes with about 50 stated exceptions and lots of subcategories in that. And enforcement, again, is through the same bounty hunt. If you're found to have not released something when asked to do so, you've got a process by which it goes up to the DA, generally for city mayors, and then to the courts. For elected officials, it's different. They're the gatekeepers for their own records. And I think that's it. All this does is talk to you about what I've mentioned before. You got to go through a process by which you take the policy, you take the facts, and you try to make findings based on the 2 of them together to address the criteria. The Oregon courts have been very deferential to local governing bodies interpreting their own plans and interpreting their own codes. We used to have an even broader view that I call the fall down laughing rule. That unless you fell down laughing at the city council's interpretation of its own code, it would survive. It's a little more rigorous than that now. But there is a great deal of deference given to interpretations of your own code and your own plan, not a state law. Courts and LUBA still look at the goals, look at state statutes. And on evidence, rarely it comes up. The one example I always use in class is dueling traffic engineers. If they're both credible, you can choose who you want to, and normally that person's testimony will be substantial evidence. But you look at substantial evidence at the amount of evidence on the winning side is subtracted by the losing side's evidence, and if the remainder is still what a reasonable person, i.e. somebody in black robes, could believe is substantial, and then the evidentiary issue survives. And then conditions, you can attach conditions to meet the criteria and carry out your plan. The only issue where you have to be careful is when you're dealing with real property, because you have the Dolan case to deal with, and you might have an attorney assessment against you if you choose wrongly. So we're all very careful about that. So I've gathered enough. If you have any questions, I'd be glad to try to respond.
It's very clearly the public records and public meetings applies to the Urban Renewal Agency as well. What else would apply to the Urban Renewal Agency Commission?
They don't make land use decisions as such, but when you focus on individual properties, I think the ante gets raised a little bit when you're dealing with criteria. For example, a storefront. If you were to deny it and somebody thought they had a good case, and probably, a judge would probably use a quasi-judicial analogy in looking at it.
I would presume if you have records of doing storefront grants before, they look at what you've done there, and whether you're
It's
gonna.
not in the record. If you have a smart lawyer, they're gonna put in what other, similar situations were like.
Mhm.
But if it's not in the record, they can't use it.
Couple of questions. First, you've mentioned Dolan a couple of times. Could you give us a thumbnail summary of Dolan?
Blather. I was on Dolan, as an amicus for the American Planning Association, so that disclosure is out there. Dolan is a case that arose in Tigard, and if you were traveling towards Newburgh and the coast on 99, and you crossed the bridge over Main Street and Fano Creek in Tigard, and you were to look to your left, you'd see the A-Boy store. That's the Dolan site, okay?
They have a plaque there.
That's right. Mr. and Mrs. Dolan wanted to move their store from across the street on Main Street in Tigard and chose this site, which was a unused site at the time. And the property was zoned to allow for the store. But there was a site and design review approval process for it. And there were, I'll pretend I know the number, 63 conditions imposed. And only 2 were challenged by then Mrs. Dolan, a widow. Mr. Dolan died during the proceeding. And they had to do with the amount of property to be dedicated for the road in front of the store. The city wanted, I'll pretend, 5 or 10 more feet from center line than the Dolans wanted to give. And then the other part was along Fano Creek, which was at the back of the store. The city said that it wanted to prevent problems of flooding, and so it required a dedication, not a setback, but a dedication of land from the creek to the city. Now, some people thought, uncharitable, no doubt, that the city really wanted a pathway along the back and they wanted it for free. And that's what the Dolan said. So those 2 conditions went all the way up to LUBA, to the Court of Appeals, to the Oregon Supreme Court, back to the city because LUBA said they needed a variance. And then went back all the way through the process, and the U.S. Supreme Court took certiorari. That's less than 0.5% of the cases. And they did it to deal with the intersection of the takings clause and real property dedications. All right. There was already a case called Nolan versus California Coastal Commission, where there was no relationship between the amount, the property to be dedicated on a beachfront. California Coastal Commission wanted to connect 2 parks and wanted everybody along the way to dedicate for free property to assure that that connection could be made. And they justified it by saying, well, everybody has to see the sea from 101. And Justice Scalia, the Lex Luthor planning law, said that that makes no sense. And he's right. It made no sense. The justification for the condition did not relate to what the public objective was. So Nolan was out there, and Nolan said, if there's no relationship, that's a taking when you're asking for real property. Dolan was a little more refined. Dolan said, if there's some relationship, then we've got to talk about the amount of that connection, that nexus. So what Dolan said was that you've got to have a rough proportionality between that public objective and what you are required to dedicate. Nolan and Dolan only apply to real property being exacted, for sure. We don't know, because the U.S. Supreme Court hasn't spoken on money, and hasn't talked about exaction of improvements. The Ninth Circuit, however, following an Oregon Supreme Court opinion, which I participated in, said that Nolan and Dolan only apply to real property. And in Dolan, it never got to trial. The city settled with the developer. But the issue was, do you really think a lot of people are going to go to an A-boy on bikes? Because that was what the money was for. They're going to take a bathtub and drive home on their bike. And secondly, isn't there a less intrusive way of dealing with your flooding concerns than asking for a dedication? So the city, in my view, got nervous and settled and gave $1 million plus this plaque on the site, which had the Fifth Amendment provision on no taking of private property for public use without just compensation. More than you wanted to know, maybe.
That's good, thanks. The other question I had, maybe this is land use 201, and it deals with intellectual property and land use applications. So when I used to work for Lee Layton, I would package these, development permit packages to governments like Oregon City. And I'd have my narrative, on the code, and then I'd have my soils report, I had, my traffic impact analysis, I had my geologic study. Once we submitted, developer paid a private consultant for all this material. And we would submit it to the city of Oregon City or the city of Beaverton. Those are public records.
They are.
Okay. If my client goes bust and that all that stuff's been paid for, and it's sitting there as a public record in the city of Beaverton, does the next developer that comes along and wants to do that same project, because it's a public record, can he use those geologic studies for his own land use approval without having to pay the geologic consultants because it's a public record, or are their consultants' rights and fees still applicable to all of those?
It's a complex response that I'll give you. For certain professionals, like architects and maybe engineers, they have an intellectual property interest. So even though it's a public record, everybody can view it. There may be some constraints on copying those things. And even if you allow it to be copied, you still might have a claim, an intellectual property claim against the person who might use it. So it's overused, but it depends.
Have there been judicial decisions on this question?
Not in Oregon, but I do know, we're all part of the city attorney network, and we talk about these things all the time. Different city attorneys take different views of this. Sometimes the planning department will call the city attorney when they get somebody wanting to do architectural plans and say, can we do that?
Thanks.
Thank you.
We'll go ahead and move on to the next agenda item. This is an update on the Ermitinger House, and it's going to be Scott Archer.
Mayor Neely and Commissioners, this is an update to you, and just want to present some information, and then also probably seek some feedback from you on kind of where we're going with this. We last provided an update to you on March 8th at your work session then, and talked in pretty great detail about the engineering issues related to the house, and the structural issues related to the house have been identified by staff and by an engineer, and we won't rehash all of that. I think you know pretty well that we've got the significant issues there. The update since that time is we've continued to work on exploring the issues, trying to determine where the course of action would be best to go. In the last 2 or 3 weeks, we've also done some additional. You recall at that March 8th work session, we indicated to you that we had done some shoring to stabilize the house and basically taking some actions and precautionary measures on getting the house at least stable. Since then, we've at the recommendations of our engineers, we've taken a little bit further action to do a little bit more shoring. So we're continuing to basically be real active in monitoring the issues, kind of do the most prudent things necessary to just at least maintain the house. And so we've done some further stabilization. We're looking at replacing the temporary plywood coverings on the windows. Those were a very quick fix to a temporary kind of a situation. We're going to make the temporary coverings at least look a little bit nicer and also weatherproof a little bit better than that plywood is. So in the relatively near future, we're going to be looking at doing either some type of plexiglass or a sealed wood that will have better aesthetic value, as well as it'll do some better moisture prevention. So we're taking some further steps there. One of the big issues that we've been looking at is this issue about the soils underneath the house, and trying to determine what the issues are there in terms of the stability. There's fill under the house. It was put on a lot that had a basement previously from the previous house that was there, and there's some type of fill that was put in. And what it is and how deep it is and those types of things, we're not entirely certain. But been looking at what it would take to analyze that situation. And after talking to at least a couple of different companies that do this type of analysis, it looks like it will take to really actually have an accurate understanding of that situation there. It will take a 1-year cycle to do that testing, and the reason is because of the seasonal groundwater issues that occur. So during one season, you might have one kind of a situation with groundwater, another one you might have another season you might have a different situation. So the recommendation is that really to do that right, it would take a full year cycle. And there's a more quick way to do that, but it is not as accurate because you don't have that full year cycle with all the different water tables and so forth. And it's costly to do that type of thing. Is probably going to be upwards of $25,000, give or take, depending on kind of the approach. There's a pretty good chance that if we, assuming that the house stays on that site, regardless of what the soils analysis tells us, and this is an educated guess based on conversations with engineers and the soil people and just staff and different folks, that no matter what, it's pretty likely that we would have to put some type of a piling under the foundation to stabilize the foundation properly down to the original ground below the fill. So it's a pretty fair guess to say that doing that full 1-year analysis might not be a very good expenditure because the chances are pretty good we're going to end up in the same place anyway. And so we're kind of trying to determine a little bit more about that. Again, for the time being, while this analysis is going on, the house has been stabilized, it's been secured. We're doing some additional things that I just told you about. In the meantime, we've been actively advocating for and looking at some partnership opportunities. Mr. Fraser has been working with our federal delegates in their offices to continue the discussion about the possibility of some legislation that would give the Ermatinger House to the National Park Service. We're going to continue to work forward on that. We've got some things coming up in the relatively near future. We're looking at reaching out to the city of Portland and having some conversations about some partnershiping there and potentially leveraging the funding that we've got, and possibly the county and the state. The state being that this is a historically significant structure for the whole state of Oregon and its citizens, not just Oregon City and not just Clackamas County. Of course, Commission, that you and the rest of the Budget Committee at your budget hearing allocated $100,000 for the next fiscal year, and assuming that stays in the budget and the budget is passed, that we'll have that. we have you at your March 8th work session gave support to staff to go forward with the understanding that we'll be doing a $25,000 budget adjustment from contingency funds for this year for the use of the things that we've been doing, the analysis and some different things. And we have not expended all of that money. I think we've spent around 7,000 to 8,000 of that. So, you know, depending on what we want to do with that soils analysis or not, we could potentially, you know, by your taking some type of action, we could put that into the kitty, if you will, and put that on top of the 100,000 that we've got anticipated coming for next year. And again, talking about this financial package and having some leverage with these partner discussions. The other options, as far as a funding, I guess we're trying to figure out is, you know, obviously the 100,000 is a start. It's a really good start, but it's not going to cover everything, and we know that. And what we need to do is, while we're continuing to explore these partnership opportunities, we also can be thinking about, you know, some of the other ways that we might put together a full funding package, depending on what other funds might or might not become available from these partners. And so these are just potential options to consider. I've just basically developed a brainstorm list, if you will, to put in front of you to be thinking about as what are some of the options that we have. And so, of course, the general fund, and again, we've allocated the 100,000 next year, assuming budget passage. We've allocated, or will through a formal action, the 25,000 for this year. There's the potential to use urban renewal dollars, such as was done with the Carnegie Center renovation back in around 2000, 2001, I think is when that was done. There's the option to, as we're exploring this parks maintenance utility fee, we could consider putting either some or all of this into that methodology and utilizing those, some portion of that to go towards the Ermatinger House. We would be able to look at private funding, foundations and things of that nature, of course grants, and we're going to be exploring that. And speaking of grants and other fundraising types of effort, I don't know whether you all know this or not, but we are in the running for an important recognition for the Ermatinger House. The house has been nominated, and lots of thanks to Christina Robertson Gardner from our planning department for her help and her efforts in this, and the Hardings for you know, lots of support information and that type of thing. But we've been nominated ourselves really for the Historic Preservation League of Oregon's Most Endangered Places list. The announcement for that, whether or not we may make that cut, will be on May 23rd, so in the near future. And Ms. Kai and I will be attending that. It's a luncheon type of event. I think the Hardings are going, I'm pretty sure. And so anyway, we'll be looking for some hopefully good news on that. So again, I was talking about grants, and then the other couple of ideas that are out there that we could definitely look at are fundraising events, and community, you know, basically community funding and fundraising events, and then in-kind resources that may be out there. Folks with the types of craftsmanship skills that we would need, or what have you. So that's kind of basically in a nutshell where we're at, what's taken place since the last update, what we're looking for, I think, tonight from you is some feedback on where you'd like to go. Again, I think where we're at right now is some really important things coming up over the next 30 to 45 days or so are these meetings with the federal delegation, our federal representatives, hopefully the city of Portland, and like I said, possibly some others. And while we do that, we're certainly keeping the House in a state where it's at least we're not letting any further harm be done to it. And if nothing else, I think we've over the last few months, we've improved the condition of the house, though by looking at it, you might not necessarily recognize that, but really we have, and we continue to monitor. So I'd like to kind of get some feedback from you on your thoughts and feelings on where we might go.
Any questions, Mr. Smith?
My question is about, if I'm trying to remember, the $10,000 from Urban Renewal went to the windows, right? And the windows are done, but they're just in storage, right? Where are they?
I think I'm going to let Denise Cog answer that.
Okay.
She's got her
I think
hand on
I
that
know
one.
the answer to this, but I was trying to refresh my brain.
We did use the full extent of the 10,000 on the window, and it did cost us a little bit more. I think the total pricing was about 15. They are done, and unfortunately, with the window frames not square, we can't reinstall them. But they are done and stored. So yeah.
And I guess they're stored in a way that, I mean, the sad thing is we have nice, beautiful windows, but they may not be put into the house for a year or 2 years, or who knows how long. So how long? I mean, I have no idea. Are they okay to just? They're stored in a way that they're going to be new when we.
Right. We have the heat back on in the house, and so they're not going to have a moisture flux.
They're in the house.
Mhm.
Okay.
They're in the new section of the
Okay.
house. And then we also have taken out a few of the windows that look like they were stressing. And so that, you know, even though there are certain ones that we were taking out just for the restoration, we've taken out a few more to preserve them.
Okay.
Ones that did not require replacement.
They did not require replacement, but they were in areas where we knew the walls were moving, and so the potential of stressing them and losing the glass was there, so we actually took out a few more.
Okay.
Was on, as a joke, I'll just leave it. No jokes. But in any case, I had asked Karen Morey to do some research, and I sent an email to that effect that we knew the Hudson's Bay Company still existed. The body that under which it exists does give grants. They apparently are all in Canada, but maybe some exception could be made since this, at the time this was built, this was still a what was it called? We were joining the occupied area. Maybe they want to make that Canadian claim at that particular point. But in any case, it's worth a shot. The joke I was going to make was she already made that with Rocky just a bit ago, but he sent an email actually talking to the city of Portland because that's where apparently the coin flip occurred, and I suggested that they don't come to any assistance. We'll call the coin flip a fraud. That actually it was Lovejoy that won, and he insisted they'll change his name to Boston. But I don't know if that would carry too much weight for that. But anyway,
That might be worth something.
I know we've got questions. Yes, go ahead.
I have a question. Someone asked before, Singer Creek goes under the street, across the street, or through the street, or?
I believe it's across the street.
It's right under the sidewalk across the street.
Okay, and then where does it cut over to start over the other way?
If I'm correct, Nancy, you can correct me, but it's just as you go past the block where Weatherford is, it starts to turn.
So it's not going through that parking lot by the house?
No,
Okay,
not to my knowledge, no.
okay, thanks.
Other questions? I'm going to give it up. Yeah, anybody, and when I see that Mr. Shaw wishes to come on forward and pose your question. Anybody else has questions? I know this is a tremendous point of interest to the community.
Brian Shaw, Oregon City. Has there a decision been made at all about just keeping the building where it's sited, or there's still that chance it could be moved? Thinking about how much this is going to cost just for the substructural work in the ground and stuff, maybe moving that across the street and have a nice fresh start here.
Well, we haven't made any decisions about that.
That's what I-
Yeah, that, I mean, there have been, I think, discussions about different options, but I think that's part of what I was getting to is with where we're at right now is while this decision-making process is kind of going on and we're exploring what the different opportunities are, I don't think we want to expend much on doing anything with the soils at this moment, just because we have, you know, a little bit of uncertainty still. So I guess the answer is we're trying to be cautious about doing anything substantially expensive until we've gone around and really worked on what our options are.
And working out some of the National Park Service, even though their expectations may be that we invest in this repairs, they do a great job on maintenance. When the National Park Service took over the McLaughlin House, they've done a great job over that in terms of things that were bad on the maintenance side. They fixed it. They did it in a manner that was consistent with the history of the house. So even if the city has to make all of the investments in the property, if the National Park Service took it over, I think the long-term prognosis of what it would be in the future would be very, very good, and perhaps better than the city could assure.
Yeah, I agree. That's something we have to think about. Is we're thinking kind of near term about the preservation of the structure itself, and that's very, very important. We've got to get that solved, but at the other end of that is still the operation of the facility and what role or responsibility and who's going to do that, you know, and if that's over time, that's probably more of an expensive undertaking than whatever the preservation is going to be. Yeah.
Commissioner Messina.
Scott, I don't think we've made the decision that Scott was talking about whether or not to make this year-long fact-finding process or not. Is that the one decision that is kind of key at this point?
Yeah, it's one of the really key things we need. I guess we need a sense from you on your comfort level of waiting to do something like that. Our recommendation is to not start that process right now, because we don't want to undertake something that is going to be pretty lengthy in time, although, you know, maybe that could be a concurrent process, so that there's that as well. But really more is just about expending funds that may or may not be necessary until we, you know, so taking basically the next couple of months or so and trying to flush out some of these other discussions, and then probably coming back and reporting to you. So yeah, that's one of them.
Okay, so you weren't looking for a decision tonight on that, in other words?
Just a sense of, if you are comfortable as a commission with us not starting that process immediately. And, you know, in other words, if there's not a sense of urgency from the commission that we should be doing that right now, but that we can have a little bit of additional time to be working on, you know, kind of the broader discussions with our potential partners.
Well, I guess my question would be, what is the worst case scenario if we don't move forward with that year-long process?
Well, probably the worst case scenario is just causing a couple of extra months or whatever of time. But like I said too, though, I'm not really certain that we need to do that year-long soils analysis. We've talked quite a bit about that, and frankly, I think we're almost at the point of saying we don't necessarily really need to do that. Denise, do you want to fill in any blanks or gaps that I'm leaving here, or is that kind of?
It's kind of the gist of things. If the house stays, we know we have some soils that are not necessarily competent soils, and so we would have to take some of that soil factor and get to a competent soil bearing. We can do soils analysis to get our base bearing pressure and still do our construction or reconstruction of that foundation. So we know we're going to take out some soils at some point. Just how much, and so do we really need to know, you know, in depth all the soil composition bases? So, and we have some factors of spending money to get information, and then spend a little more money to the bearing pressures if it stays, and then more money to take care of the base foundation factors, or knowing that we're going to do those other two things, do we really need to spend that factor? So, just trying to be fiscally smart and making sure we're making the right choices along the way, depending on these other decisions.
Again, we may not need to do this year-long soils analysis process, is what I'm telling you. We're still kind of filling that out a little bit. This is kind of newer information that we're just recently working through, and we just want to work through that a little bit more. Okay, thanks.
One of the things I might add is that I think one of the reasons we're going to hopefully, I'm optimistic about these discussions with the potential regional partners, and I think one of the things that makes it different is the level of funding, not only the 100,000, but this additional 20 some that's left, to bring that to the table, because usually cities bring the federal government problems without any solution or any partial solution. And I think we're going to get more attention because we do have that commitment. And what I wouldn't want to do is have us spend a portion of that nest egg, if you will, that we're bringing as a solution, on a solution that they may not agree to or be part of. And so we want to have that discussion before we commit, so we get the most bang for the buck, if you will. That, for example, the Park Service could say, well, we'll take it on, but not there. We want to move it across the street, and there we'll have spent that money on a soils analysis. And so anything we do to diminish our nest egg there makes the project more onerous for the partners. And it also whittles away at the match that I'm going to be asking them to consider. How much, the more we were putting in, I think the more compelling the story we have to ask for assistance.
Mr. Lee.
Dan Maybe, Oregon City, and a historian. First, one thing is Mr. Shaw's suggestion, I heard a gasp in the back, but the fact is across the street, you can put a laser level slab in there, and then at least you're truing up a building from a true foundation. If that isn't a possibility, an alternative to a large soil study, I mean, the problem is it's the basement of the old police station, and they probably just shoved the whole building in and walked away from it, much like most buildings are doing on their own, is to build a larger foundation that encompasses that older foundation, and then lift the building to that, so that you're building a foundation on solid ground, so you don't need to be driving 20-foot pilings or whatever, and then just put the building on that foundation. It might require creating a platform that it's on, but again, it would be a laser level platform that you'd be building to, as opposed to trying to put in a piling and then level that up and all that. It's just, at a certain point in time, to be honest, as a taxpaying citizen, on the other side of it, I mean, is how much is disassembling the building and building it right? I know there's, how much can we spend before it has no value anymore? And I'd love to true it up, to put it back the way it belongs, and have somebody, like the National Park Service take it over. But we got a police station that might fall down in an earthquake. We got a water master plan we got to get. We have a South End concept plan. We've got a Park Place concept plan. We've got parks that need maintenance. I mean, we need like $20 million to straighten this city out. And, if Hudson's Bay doesn't care about the house, if Portland doesn't care about the house, if the National Park Service doesn't care about the house, well,
that's what we're working on.
Then we need to decide our priorities, and I think if we can at least get it level, I mean, the thought that, and we need to do it sooner rather than later, because you can only jack up a jack so far before you reach the end of it. And so,
Damon, do you know who owns that house, that lot across the street?
proposing moving
We're
to?
talking about city property.
Well,
Pioneer Center was the.
yeah, it's the open land adjacent to, which is part of the Peace Park and all that.
Which
So,
is what the reaction was,
yeah,
not about,
there's other issues about
it's
that
about
land,
being
but,
near that lot.
but, you know, doesn't prevent us from moving the house there and rededicating Peace Park where Ermitinger is.
Or,
It means we save them both.
if the National Park Service wants to take it on, they might want to see it sited next to the Blackland House.
Yeah.
So, I mean, I think all that is really up in the air, you know.
Yeah.
But what you're saying is don't leave it up in the air too long.
Right, because it's clearly not floating very well
No,
already,
it's-
so. But anyway, thank you.
Yeah. Any other comments? Come on, yes, come on, please.
My name is Ed Wagner.
Yep.
I'm not a citizen of Morgan City. I'm a citizen of Portland, but I have long-standing interest in this town.
You sit for just a little bit more to catch you on the mic there.
I have two comments. Been involved in similar kinds of activities in the past, and I don't know if it's possible to think of the term basement here. But it might be an easy solution. I don't know that it's applicable to this. Maybe this house only can take a short foundation. But the Victorians that I've dealt with before have all had basements, and they were brick foundations, which have lasted over a century and have withstood all the earthquakes that we've sustained here. Second comment deals with how you get it done, and you can look at a format like Habitat for Humanity, which draws from resources throughout the community on a donated, contributed basis, both materials and labor, and making this a community effort where lots of people or select groups of people decide to take this on as a mission, especially where you have Clackamas Community College with some expertise there, and all the trades that you have here, people working outside the area, maybe they can work inside their city now, but thinking all the time of only hiring contractors is a real constraint. I've been involved in a couple of projects similar to this, where costs were really minimalized. This was several decades ago, but we did one basement where we excavated the whole thing, put a brand new foundation under it, cash out of pocket, and a lot of volunteer help, professional volunteer help, not, hacks and do-it-yourselfers and, Archie Bunker types, but real talent, contributed labor, and we did it for less than $8,000. It's a different time and different economy. But when you're talking about only using the most expensive labor you can find and doing everything on a contracted basis, you can easily let costs soar. Thank you.
Any other comments? Mr. Smith? Mr. Rock, excuse me.
Well, I wasn't clear on what you were telling Brian about moving it across the street. Where does that fit into your plan of it, looking into that?
I hadn't specifically, to my knowledge, we hadn't specifically thought of that location, but we haven't made any particular decisions. I think Mayor Neely said it pretty well there, that we don't want to rule anything out at this point, depending on what might be the prudent thing to do financially or structurally, or depending on what our potential partners say.
So is that something you will bring into your line of things you're looking into right now?
It's a consideration. I think our main focus right now is talking about whether or not the Park Service has, or whether we can do something with our legislators to work out an arrangement with the Park Service. And so I think what Mr. Frazier was saying is we'd want to know, and we're working on this question, is what would be their preference. So I guess I'm not ruling out that option is what I'm saying.
Okay, my question is, the bottom line is what kind of timeline are we looking with the federal assistance or federal taking the project over as compared to taking this through another winter, which is probably going to do substantial damage?
Well, the way we've got this designed is we're trying to establish staff level meetings with the staff at the various federal leaders that are going to be involved and the National Park Service, because we anticipate a number of technical or legal potential hurdles to do whatever we do down there. And we don't want to waste the time of any of the elected officials, so that we want to try to do that background work at the staff level. So when we get the elected leaders assembled, probably in August, given people's vacation schedules, that we will hopefully be able to make some decisions then and have them weigh in a supportive fashion and try to leverage additional dollars. So I think we probably will be looking at an additional winter. However, I don't know yet. There's just a lot of unknowns. It's almost like I feel like we're having this conversation and without the Park Service, and we have talked to representatives from the Park Service, but I myself have not talked to a decision maker. It's a big organization, and so we're trying to talk to the staff level that we're familiar with, and then work our way up to a staff level where we think the decision will ultimately rest. And I'm pretty sure, based on my meeting with Congressman Schrader, that the Park Service at or near the superintendent level is the key. As far as I think if the service is interested and their concerns are addressed technically and professionally at the staff level, then I think we have a shot at it. But it could be a multi-year effort. In other words, we may be back to you next spring during budget season saying, well, we still have our 125, we have a building that's stable but not open, and we think here's a chance. How many more years do we tap the general fund to try to do this? We may come up with some matching grant funds. I think we just have to keep focused on this, and it may take a couple of years, but I've kind of got my teeth sunk into it, and we're gonna keep doing it until we get somewhere. I wish I could be more specific, but I just can't until we talk to some of the more senior people at the Park Service.
Yeah, and a little bit more to your question about the concern, Commissioner Roth, your question about, on another winter or another season or another year, as Mr. Fraser was talking about, it may take a little bit of time, but I think the preventative steps that we've taken and the shoring that we've done, and then we've even done, as I said, a little bit of additional shoring. We feel, there aren't any guarantees, and you can't say anything with 100%, but we feel relatively confident that it's stable. We're going to continue to monitor that. We're working closely with an engineer. It's just something that we're monitoring very closely. So, we feel relatively confident and comfortable that, I'm not suggesting that we're advocating for just sitting around and doing nothing for a long time, but I think tying into what Mr. Fraser's idea is and where we hope to go. So we're going to just continue to monitor that.
And at the end of the day, if we end up, let's say that I'm calling this thing the Army Summit that we're trying to get together for August. But let's say we get together and we either hit a snag at the staffing level or we hit a snag at the elected level, and maybe there's support, but it's rhetorical. There's not additional funding, and we can't get matching dollars, and we can't get grants. And let's say that we end up, hey, this is your problem. Nobody wants to help. It's all up to you. Well, I think at that point, then both Ed and Damon's ideas are going to be very heavily weighing on my mind as far as what's Plan B, Plan C even. The fact of the matter is, if we're really determined to say this, and I think you have made that commitment as a commission, we're not going to stop. We're going to do whatever it takes, as long as it takes.
Are you working with in Kurt Ferry's office?
Yes. Who am I working with? Allison. Yes, chief of staff. And I did get to meet with Kurt face to face for about 10 minutes last week on that. So we'll just you know, it's a process.
No, Commissioner Smith and then Mr.
That guy back there.
Mr. Hardy.
So I think that you're making the right decision. I think that I mean, even within the next week, we're going to have some pretty big answers, hopefully, and even in the next month and 2 months, I think we'll have even more of an idea of the resources that we may have available. So I think that that's the wise choice, because we don't know, you know, what these partners are going to bring, or if anything. So we want to kind of feel that out. And I think we're making a lot of progress on that. So I'm excited to see that. And so I'm kind of wanting to know what the answers to those questions are, or what the answers. I'm very interested in this League of Oregon historical. I've been saying this all day. Historic Preservation League of Oregon. I'm anxious to hear about that. I'm anxious to hear just what all these partners have to say about it, and I think by kind of stockpiling that money that we've already earmarked for the house, I think serves its purpose to just sit there. I think the house is probably more stable now than it has been in a long time. I guess the main concern I would have is the winter coming up, and how we prepare for making sure that the windows are sealed, and I think that's what we're working on. And so even though I cringe every time I drive past the house and I have to just look at it, I feel that it's in the best place it ever has been, so that as long as I've known the house. And I think I'm excited to see us at this point. And I really think it's going to happen, and it may take a year or two, but it's going to happen. We just have to keep fighting on it and working on it. So anyway, I really appreciate the Harding so much, and the staff and the commission. Everyone has said this many times. You'll hear it 15,000 more times probably before it's done. But we're doing the right thing.
Mr. Mayor?
Mr. Hardy, your direct response to Commissioner Smith?
I just have a response that I wanted to add to that. Today, I directed Scott Archer to begin to put together, and what I call it is sort of the Ermatinger story. Because if I'm lobbying anyone, I think the House has to tell a story that's compelling. I don't have the kind of knowledge of it as many people in the community do, but I know that I talked to Commissioner Smith tonight before the meeting, and he suggested that Dan Fowler may have a lot of pictures and photographs of the house and its different iterations over the years. If anyone in the community has access to that kind of information and can get it to Scott in the next few weeks, he's going to be working on putting that together, and so that if Mayor Neely and Commissioner Smith and I get to meet with Sam Adams to talk about this, we want to have something to leave in their hands. You know, a color version or a black and white version, I think, would be more compelling of what the story of Ermatinger is, and why is this a structure of statewide importance to the people of Oregon. So that's what I think that is something the staff is working on. And then just this past week, I know that my assistant made at least a half a dozen phone calls to various of these political figures I mentioned, trying to check schedules. And so all I can tell you is we're moving as fast as we can to make something occur here. And I'm very determined on this one, and I know you all are too, and so we'll just keep at it.
Ron Harding from unincorporated, but very close. Point of clarification, just kind of historically, moving the house across the street, that battle's already been fought once. When Mrs. Powers moved the house in '86, they were going to initially put it there, but there was such an uproar by the people, the folks in that area, especially that frequent that area, that they decided to move it over to where it is, unfortunately. As we see now.
Well, Robin, what were the issues involved? Why was there such an uproar?
Well, they wanted to preserve that park area. They just didn't want that big, well, big, relatively speaking, white monster sitting there. And especially with all the things that had to be done to it when it was moved eventually, all the renovation and work. So, other than that, I don't know specifically what it was, but I know it, according to what we've read, it was a major issue, which forced them to move, for Mrs. Powers to move. Mr. Fraser, thank you for your enthusiasm. It is behalf of the Hardings and all of our friends who are so interested in that house and love that house. We appreciate your determination and anything we can help. I'm on the McLaughlin Memorial Association board and past president, and have worked with the Park Service closely with that facility. One of the mistakes that was made politically when the Park Service did the legislation to get the house is that there was no operating funds with the bill. And so they were left with property that they had no money to operate. So I caution you, city, that if indeed you're in that position again, that you try to make sure that there's going to be financial operating funds tagged to it, federal funds. As the Park Service right now is stretched beyond their ability. As many of you know, as a member of our trustees, that we've had to, for the last 3 years, to contribute to keep a ranger at the McLaughlin House. We've had to financially help support it. Otherwise, the McLaughlin House would be closed. And that may be a reality if the budget information we're receiving is true about the massive cutbacks to the Park Service. So there are some issues that hopefully we'll be aware of when we negotiate or whatever we have to do, bribe or plead. So please be aware of that. But again, I appreciate your determination to get this thing done. And as Commissioner Smith, we also have a tear in our eye when we drive by because of our long-term attachment. And we'd love to get it open again and tell its story, because it has an important story. Thank you.
Yeah. Any other comments? No, we'll go on to our break. 20 after.
Thank you all for your work on this. Thanks to staff, John and Denise, and thanks to the citizens who made comments tonight. They're very thought-provoking comments.
We've got a final agenda item here, and that is the White Oak and Significant Tree Protection discussion. When we talk about staff, this is one that Commissioner Nocita brought forward. I don't know if you want to say anything first, Commissioner, before Mr. Conkle speaks.
No, just to thank Tony for the information he provided. I also provided the Commission by email tree report that had been done regarding the public works site, I think last year, and it actually had some specific identification of white oaks in the area and their DBH, and it kind of, in some ways, was almost like a findings of fact for applicability of those trees to this ordinance, and I was interested in reviewing our Heritage Grove ordinance, and wanted to hear some more from Tony and from Nancy on this.
Okay, so I wasn't exactly sure where you wanted to go. So I'll start right there. So what I did is I went through the code and kind of identified the three primary sections of the code that deal with tree protection, preservation, and mitigation, and also provided those sections as attachments and memorandum that you received. But generally what we have in Chapter 1720 was recently updated back in August to include residential landscaping for new homes, The amount of landscaping and the number of trees required per lot are dependent on the lot size. The next section deals with tree protection standards. I guess I should back up there. And what we were seeing was the previous code addressed tree protection and preservation and mitigation when you did a subdivision. So what happens is you come in, you do a subdivision, you identify the trees you're going to protect, you put all the public infrastructure in, you go to the county and you record the plat. Once you record the plat, those lots become legal and they can be sold to anybody. So once those lots are sold, if I go buy that lot, those protection standards didn't run with the land. It was just through the construction period. So as a private property owner, because we don't have a tree ordinance in Oregon City, I could go cut that tree down. So these new single-family house landscaping requirements will help address that, because if the developer protects that tree on your lot, and then you preserve that tree when you build your home, you've met the landscaping. In most instances, you're going to have met the landscaping requirement. If you take that tree down as part of your home construction, you're going to be putting some type of a tree back on the site. Now, the next section are the tree protection standards in 1741 of the code. And what we tried to do here was provide not only the mitigation measures, which we've expanded. Historically, if you came in for a subdivision or commercial development, wherever the public road was or the construction site, so where the building was, if there were trees located in those areas, you got to remove those and there was no mitigation associated with that. So we created a two-tiered system whereby if a tree is in a public right, where a new street's going to go or where a building is going to go, that tree can be removed, put the road in, but it's going to be mitigated, but it's mitigated at a lesser standard than if you're just going to go in and cut a tree over in the corner for really no particular reason. So we upped and tiered the replacement mitigation measures, but we also offered incentives this time around. Whereas if you identify specific trees that you want to save and you record a covenant or an easement against that tree or a grove of trees, we offer some flexibility in the subdivision code where you can reduce lot sizes, you can reduce setbacks, and there were thresholds set in there to try and incentivize protecting those trees while maintaining the density that you're allowed in the underlying zone. So if you're allowed 10 homes at R10, you can do 10 homes with a smaller lot size or shift the setbacks if you protect trees on the site. The next section is 1208, which deals with public and street trees. So we've once again gone back to, we've identified, we have street trees throughout the city. And as you're well aware, we do have some issues with sidewalks popping and whatnot. So we also have a two-tiered system here. If you have a perfectly healthy tree and you want to cut it down, the mitigation measures are higher. If you've got a hazardous tree, a diseased tree, and it's certified by an arborist, you're looking at usually a one-to-one placement. If the tree's causing the sidewalk to crack, you're looking at a one-to-one replacement. If you have a 15-inch tree and you just want to cut it down so you're tired of raking the leaves, you're probably in the mitigation of about 5 to 7 trees that need to be placed on in the planter strip on the property, other places in the city, or we have a pay and move system now of I believe it's about $275 per tree that would go into a tree fund for future use. I also provided in that street section is also where we have the heritage tree program, and that lays out how we go about identifying heritage trees and the process and the minimum standards that go into the approval of such a heritage tree or heritage grove. If it's on private property, it needs owner consent, and if it's on public property, it can be nominated, and then it goes through the hearing process or the public hearing process, whether it's on private property or public property. So with and actually we haven't seen a heritage tree nomination to date, but when we were...
Kill them all. I think they're gone.
When we went through this process, we always seem to begin the changes to the tree code with the conversation of should we regulate trees throughout the city. We've gone back and forth on that, and we've made incremental progress, expanding what we protect. The mitigation measures have increased. The opportunity for altering lot sizes, altering building locations, altering setbacks have been increased. So we're trying to provide both the incentive as well as the mitigation, and trying to raise that standard so that, you know, the trees do become incorporated into the site design or the lot pattern or the street design. So I've also included in this a memorandum from Walter, which which laid out some of the concerns or what needs to be thought about in terms of how we designate trees if we're going to look at a citywide code for tree preservation. We also worked with the Natural Resource Committee when they were in place, and we worked with Department of Forestry, and their recommendation was that, you know, you really focus on the education component up front and get the community buy-in. You know, why are these trees important? What is a significant tree? What are the benefits associated with it? You know, getting our Tree City USA recognition, really working with the neighborhoods. You know, if we can have neighborhoods identified, teaching them how to prune trees correctly, have plantings in those areas, really build up the education and the community buy-in. And then you can start that conversation. What they find is that then you can start that conversation of regulating trees citywide if you so choose to go there. There's nothing that says you can't do it first, but, you know, her recommendation was, you know, you really have to get the word out in the buy-in and the education to make that process go smoother, because, you know, as with anything, when you start to put restrictions on private property, you know, you are going to get some pushback, and to what extent depends on how much work we do up front to try and address the concerns. So, just a quick kind of where we're at right now. I'd be happy to answer any questions. And I wasn't, like I said, I wasn't exactly sure where the conversation was going to go. So,
if I might just follow up on that, Tony. You made a confession that you weren't sure where we wanted to go on that.
Right.
I'll make a confession that when I raised this issue when I raised it at a prior city commissioner work session, I didn't know where I wanted to go with it. I had a generalized, value. I wanted to promote a value of tree preservation, and I didn't know. Honestly, I didn't know the specifics of our tree ordinance. I mean, that's probably a confession that my fellow commissioners on this dais will probably admit to, in that, the average city commissioner who has to go out and make a living doesn't have time to review an entire monster binder of code revisions, and I didn't read the whole thing. I just remember reviewing the code revisions. So I'm not, as an expert on our municipal code as I would like to be. So what you've done here as a favor to me, and I thank you for it, is bringing this process of the Heritage Grove to my attention, and I'm sure through other people's attention, because I've been sharing this code section, and the distinction it makes between public land and private land. I think one of the things that has struck me since I've been on commission is in the debate on trees, like the ordinance the county tried to pass, and the whole public-private tree issue. I have always been struck that governments tend to be the worst offenders on trees. I've just what I've seen happen, in Clackamas Park and Clackamas Cove and the Park Cities. I'm always just kind of quivering about what's happening to our canopy in this town, and my generalized values on tree protection, and this sensitive, what I find is a very sensitive landscape and ecosystem of Waterboard Park. I was kind of groping for a mechanism by which we could, as a community, have a dialogue and a discussion on that. and have citizens participate in that process. And when I read the Heritage Grove ordinance and the fact that, you know, a citizen or a group of citizens can start that process, that was very encouraging to me. And the fact that, you know, the city, you know, be it on the promenade, be it in Waterboard Park, you know, and numerous other places, you know, we have in this ordinance a set of, you know, standards. And if something meets standards, we have a mechanism for applying, you know, a real life situation, you know, with these standards. So, having reviewed these, I want to begin the discussion of nominating not only the White Oaks and the former proposed public works site, but also Waterpark Park as a whole as a heritage grove. Gordon Wilson, a citizen of McLaughlin, who's really been passionate and dedicated on this matter, has come tonight. I hope he'll be able to speak as some folks were able to speak on the Ermitinger House. But I do want to have that conversation on getting that process started of nominating that grove. And, you know, obviously, you know, there's implications for that, especially with our facility siting. But I think it's something that I want as part of our facilities siting planning, because in the documentation I read on the siting of this in the 2005 study, which I did read assiduously, there really wasn't a discussion on the sensitivity of the ecosystem in that area as a factor in choosing that site. And as we move forward, my preference, and I've stated it already, is that this ecosystem in that area, both in Waterboard Park and immediately adjacent to it, is so significant that it should be set aside as an ecosystem restoration area. And I'm very in agreement with Commissioner Roth on how, at least in the non-hazardous areas of that area, there should be a discussion on some sensitive and architecturally attractive infill housing, perhaps on the north side of John Adams, where I don't think the landslide risk is significant. But that's another discussion. But I kind of see this as kind of making the first values statement through our ordinance and citizen participation process, that the White Oak ecosystem there, and Kathy and I went up to the area last night just to measure in the ordinance. The White Oaks are 8-inch DBH to be eligible as a heritage grove, and each one of these trees was well broader than 8 inches DBH. So that's where I'm interested in moving on this, is get these White Oaks dedicated or listed, and having the value statements that's inherent in that listing guide us moving forward on planning both for that site as park and ecosystem restoration, and moving forward with the Public Works Operation Center at another site, because this site is not appropriate because it is heat sensitive as an ecosystem. So that's my blather, that's all I'm going to say.
Before I guess, any other commission comments? One thing, I mean, expanding on to it a little bit, I don't know if our mitigation is actually species specific. Oftentimes if you have planted, of course, the parking strips and so forth, they're not indigenous species anyway. But even if you moved out of the Waterboard Park area, if there's in fact construction going and where you have trees, be they white oak, madrone, or whatever, that are significant, I would say that our mitigation should be specific, species specific as well. And there, for example, you deal with white oak and madrone. I think there are large areas of McLaughlin Promenade Park, which in fact would be suitable habitat for those species. And so that's something else you might want to incorporate into anything we discuss in terms of having specific species-specific mitigation where we're dealing with some indigenous species.
If I could just add, we added a list of preferred tree replacement, and if you, for example, you place a white oak, you get the minimum standards are 2-inch caliper tree. So if you put in a 2-inch caliper white oak, you get to count it as 4 inches. You get to double the. So it's more on the incentive side, where we're trying to promote the tree species that we identified to be replaced throughout the city.
Gordon, you want to come up?
I'm Gordon Wilson, Morgan City, 107 Jefferson. I think it's a great idea to have our first, heritage oak grove or heritage tree grove. Since we don't have one, I think that's kind of a shame because there's actually just Waterboro Park is a magnificent grove of trees. I didn't know anything about Oregon white oaks till the past year or so. I've really been educating myself, and these are really great trees. And it's not just a tree like you can get a tree and then plant another little tree. It's a whole ecosystem, and it supports a wide range of animals and plants and butterflies and frogs and everything. And so I'm all for starting out having the heritage tree, but I think Oregon City actually has a lot of different great trees I've seen. Oregon City, one thing people I don't think realize from out of Oregon City is how much natural wonder and beauty there really is in Oregon City, and I don't think get much credit for it unless you come here and look at all that stuff. And that's one thing I think would be real important to preserve, because also if you go down from the falls and then up through the promenade and then up through Waterboro Park and then around, there's a whole loop, a walking loop that's a really great loop of trails and stuff that I think offers a lot of value to the whole city, but also to the McLaughlin neighborhood. I think it's a great idea to start, if we have a heritage program, to start having these heritage trees, and I would like to be involved with helping. If I always thought if it was public property that I don't know what to do if it was private property or something. I was more, I don't know how it all works, but if I never even knew what a city's comprehensive plan was before, a year ago. That's something else that I've learned about, and I read it, and it talks in that about how Oregon City values open spaces and rock outcroppings and trees and stuff. And to me, it seems like such a shame to cut all that stuff down, or a contradiction to our own comprehensive plan. It just seemed like the opposite of it. And also, I've been reading in my researches, all over Portland and the Willamette Valley and stuff, people are spending millions of dollars to save one white oak and try to make an ecosystem from that. But hopefully it'll come around in 30 years or something. Whereas we've already got these huge native white oaks and the whole grove that we would just cut down for a parking lot or something. It just seemed crazy, within a geologic hazards area and within a historic residential area. It really upset me because I couldn't understand the logic of it all, because it seems so illogical. And so I think that'd be a great idea if we could save those as heritage trees.
And I was going to comment that the white oak savanna, of course, is an area that's being lost. The reason I think it was so extensive is that pre-Western settlement of this area, one of the major things that was done here is the use of fire to create habitat for game, and that was one of the reasons for the extensive white oak savanna that was here, because it was fire control. Even in the, I did a tour of some of the open space procurements by the Metro in the Washington County area, and there were actually very old ponderosa pines that were there, which amazed me. But they were part of the trees that could flourish under the kinds of controls that were being implemented at that time. And of course, now that kind of use is gone and things have been plowed for agriculture. Those areas are really sensitive, and I agree with you. I think they ought to be preserved for their historic value as well as the natural value of those systems. That's why I say I think where mitigation is necessary. I think we've got areas where those be they madrone, white oak that we see in the open space procurement of Metro and just south of the Kenema area, but also areas that we have under city ownership that we have to look at that. And if we are going to mitigate, it's going to be a very serious mitigation effort. Yes, sir.
I have one thing to, and I'm not sure this really fits in here, but I'm going to bring it up anyway. In reading the report from June 3rd of 2010 by Applied Horticultural Consulting about the property that we're talking about mitigating on, it talks about the critical tree protection zones and how the site that's planned for that zone we just need to take the trees out because there would be no way of protecting what's there, the ecosystem or the trees that are there. And so I think that really speaks well to preserving this and moving on to something else, the public works, this in conjunction with this tree mitigation and heritage tree. So.
Not really. I guess that I agree that we should talk more about those trees and that specific cluster probably too, but I don't necessarily want to jump the gun in front of the discussion for the public works building itself. I think that that discussion needs to take place. That's happening at our next, it's coming up pretty soon, June. So I think this discussion should continue along the same time as we start talking about the public works site. I think, I would hate to make any decision strictly on the public works site, even specific to the trees, until we get the presentation of all from public works and the alternative sites and all that kind of stuff. I think this discussion should be happening kind of in parallel with that, but I'd hate to jump the gun on this before we really know what the options are fully with public works. I have very strong feelings about that site for public works. I have very strong feelings also about this topic in terms of the trees, but I don't necessarily think this has to happen before that. I think we need to know what's happening with public works, and I think we have to have a decision on that. If public works stays on that site, then it stays on that site. If it doesn't, then we tackle the tree problem. So I think the conversations that have to keep going parallel with each other rather than using this as a tactic, even though we already pretty much know that the majority of us on the commission are not comfortable with public works. So I don't necessarily think we need to completely pick it apart with every little thing. This, I think, is valid, but I think they need to be happening at the same time.
I was going to put something else that out. I know the rezoning subject's coming up, but I think what we need to have is a presentation on the safety issue, which was one of the main reasons you put forward. I suggested Scott Burns, and you suggested another person, I guess, that lives in the area.
Jim Roddy.
Yeah, to come forward and talk about safety issues, because I don't think we can, whether it's current zoning or some future zoning, we've got to know what the safety issues are before we do any zoning in that area, rezoning in that area. So I think there are a whole lot of conversations that really have to precede that, and And I agree with you on that. But I think we need to put the issues out there so we know what we're going to talk about.
Right, I think they're intertwined.
Oh,
I think they're all-
they're all intertwined, so it's kind of hard to.
The other thing that I just wanted to interject is if we're looking at another site, we don't know what the zoning of that site is. There's a lot of land use process that has to occur, not only land use, but there's also potentially property acquisition. And the costs are something I think that we owe our public to consider. And I want you to trust me when I say that I'm a big fan of preserving our natural resources in Oregon City. For some reason, I think I've kind of gotten the impression that maybe some folks out there think I don't value them. I certainly do. But I also have to run a department that has limited resources and go out to the public and ask for money based on what I hope we can all agree to together are really the best solution for the whole, kind of look at it globally. So just that adds another intricacy to your guys' decision, is that there's sort of the utility side of it, and there are quite a few needs here that we're trying to meet.
This is not a decision, but I want us to see rush. And that's my major concern. I need the dialogue. So.
Tony, can I ask you just, can you describe for us the process when a citizen takes the initiative to designate a heritage grove? Yeah.
So I'm pretty much going out of the code since we haven't done this before. So it would be a recommendation for designation would come forward. The city would.
That's kind of like the initial process. I'm interested in what the code describes a form.
Right.
If this has never been done before, I guess my first question is, do we have a form?
Because I believe we actually did this quite a long time ago.
Yeah.
And I believe as part of that process, and it may have initiated with the Natural Resource Committee, Pete Walter was working with them at that point, and I believe that there was a form created. If not, it's not going to be very difficult to put together, but I don't have the answer for that right now. So yeah, we would have a form come in identifying the grove, the trees, why they're significant, preferably addressing the 4 approval criteria, of which the recommendation comes to you to make that final decision based on. We get the recommendation, we review the tree, prepare a staff report, bring it forward for a public hearing. And then the commission makes that decision to designate or not.
Question: what number is that? It's a code?
It would be in.
I can tell you where it is on this.
12.
Gordon, I emailed it to you this afternoon.
1208.040. 12.08.040.
Thank you.
What I wanted to suggest was, and so the citizen or a citizen can submit a form, then you process it as the community development director. And what are you? Okay, it didn't seem to me from the code that forwarding it to the commission was automatic. It seems that the director is kind of a gatekeeper there, and that the citizen wouldn't necessarily get a hearing.
Review process, the city commission shall review.
I think it comes to us, we review it, we make a recommendation, we submit the recommendation to the city commission.
Good question. The designation of a tree by the citizen is for a tree on their own property, or can apply to any tree in the public or on their own property? I presume they can't designate something on their own, on somebody else's property.
Not without owner consent. They could request it for their own property, or they could make the request for public property.
Right.
So, I mean, I'm looking at section G1 there.
Yep.
If the proposed heritage tree or road is located on property other than city property or public right of way.
So that's private property.
If the proposed heritage tree or grove is located on city property or public right of way under city jurisdiction, the recommendation shall be submitted to the community development director if the recommendation is consented to by the city. The community development director shall submit the recommendation to the city commission. And on that little clause there, if the recommendation is consented to by the city, is the one that I'm curious about.
I think that we are, in the end, responsible for the city manager, responsible for the properties. You know, if this were a tree, and I'm coming up with a worst case scenario off the top of my head. We've got a transportation system plan project that we're about to initiate, and someone wants to designate a historic tree that's going to be taken out, as part of a roundabout. That might be a situation where, you know, we look at it and say, you know, we've got a plan in the transportation system plan.
Or a public works building.
So, yeah, at some point the city has, as the responsibility of all the public lands, we have some responsibility to review these and consent or not, depending on where they're at and depending on where the location is relative to if it's a significant project that's needed or whatnot.
I presume you can go through the assistant can go through the same process they could in the land use issue. They could actually request it to come before the city commission. They may have to pay something to do something, but they can do it.
Commission can waive.
Yeah, you know.
Or the city commission can waive. Yeah,
correct. If it's a neighbor's, yeah.
So it's the same kind of process.
Yeah, but I think we're also in a situation here where if the city commission directs us to designate a tree, obviously we're going to bring it back for your consideration.
Just to clarify now, heritage tree. I'm thinking of our local inventory of houses, historic houses. A person can request their house be included in the local inventory. It goes through a process.
Correct.
Okay? And that process might result in being put on.
Correct.
Once that's done, it kind of goes to the title that house is forevermore.
Correct.
Does that apply to? I presume that applies to heritage tree as well.
We do have a removal process for heritage trees.
But they have to go through a property owner has to go through a formal process to de-designate.
Correct.
I presume you could de-designate something that's on the local inventory of historic houses too. Probably a little harder to do it.
It's a little bit harder to do.
But I presume a person could do so.
No, the case law is concerning a public jurisdiction. A structure was designated. The time to request that the designation not to happen is during the designation process. So went through the designation process, went on to the historic inventory. Multiple years later, they want to take it off. Citizens objected. They took it up to LUBA. LUBA said your time to request that it not be put on was during the designation process. You know, if it's a private home, you know, I suppose there could be a situation where citizens could contest it. It's probably not going to be nearly as common as a public resource. But that's kind of all we've got out there right now.
This is kind of in regards to your gatekeeper concern. Being the paranoid person I am,
you replace someone who is paranoid.
That's why you replace me.
That's what's my mind.
I can very much see a reason for him being a gatekeeper, because I could easily see, and I'm basing this off of an anecdote of a group of people wanted to stop a development down in Arizona, so they transplanted a rare fish to a little pond and said, can't build. is if you don't want a road to go in, if you don't want a development to go in, you go to the local nursery and you jam about 35 saplings, white oak saplings in, and then you file out form for each individual one. That if it has to come to the city commission, you just jammed 3 or 4 commissions just for those hearings, and all they are is just a roadblock. But if he can say doesn't meet, then they would come to you as an appeal, or $250 a pop. If the person still wants to drag them up in front of you, then that's fine. At that point, they're spending money and off they go. But so I can see a lot of reasons for there to be a gatekeeper. And the council always has the right to waive if they disagree with that. But I mean, it's not that tough to go buy a madrone sapling, get billed.
That's some pretty significant processes in here for tree sizes at certain heights and everything.
Sure, but if he's not the gatekeeper for that, then every form, even if it fails to meet those check marks, would have to come to you.
Oh, okay.
So that's why.
I lived in Korea for about 3 years, and trees were very special to Koreans. For one thing, they pretty well got decimated during the Japanese occupation there. They were mined and so forth, and there weren't very many old trees. But I saw 40-year-old trees being moved and transplanted successfully. I also saw roads that actually went like this around a historic tree. It was that important. Now, they may not have the same values now that they've developed so much as they did then. It was very impressive to see what, in fact, could be done. Yeah, even if it interfered with public transportation or anything else. Things could be done, and you could have people saying, well, yes, but this is a 150-year-old tree that you're talking about running a highway through. Figure out some other way to deal with it, and that would be a basis to bring something before the city commission.
If this came forward in the example that I gave, what we're really measuring, and this is under section E2, the burden imposed on the city by the continued presence of the tree outweighs the public benefit provided by the tree. And that's where you start to weigh what are the transportation or infrastructure or safety costs associated with in that one instance. I see it potentially being very rare. This was meant to be proactive rather than, but I understand your concerns as, the discretion that I have in bringing those forward, but I don't take that lightly. So
I'm kind of curious of what disappeared when Highway 213 went through. I'm sure things did disappear.
I think the ordinance even gives the staff the prerogative to bring things to the commission and initiate it ourselves if we thought, particularly if we had a project coming and we're like, well, we've got trees that we really want to save, checking in with what the values are.
Yeah.
Well, I'd like to propose something, and I think there's an opportunity here. We have at least one interested party in Gordon, interested probably, I think, in submitting an application, and I think this, that triggers a process, and that process that, the submittal of the application is kind of like, to me, the beginning of that parallel process that Rocky was talking about. And I'd like to see that process commence and see where the process goes, and just let us flex our, tree muscles and exercise this ordinance and let the process take its course. If nothing else, we'll get a form out of it.
Yeah.
I'm really getting the form, but I'm also, I believe that, we should, the public works is important also, and, if they have to go there, they won't go with the trees, but if there is a better place for public works, or if the public works just can't work there because it's not a big enough space or something, then yes, I definitely want to do the form. If I do the form once and it gets denied, can I do it again later, or is it always denied?
I guess we're all learning. That's why I kind of like to see this experiment happen.
Sure. Well, I mean, I'd like to wait if I'd have more chance for.
I'm glad you said that, because I do think that before we talk about zoning, whether public works is there or not, I think we have several issues that we need to discuss. And my purpose is that this does not come forward here, and in the process, put ourselves in a situation we haven't been able to really effectively discuss the other issues involved.
Exactly. What else?
So I get the form, I turn it in like a month or so.
I don't think that'll stop us from developing a form.
Right. Or, thinking about the process.
Sure, do that.
Great. Thank you.
Anything else for the good of our order?
City manager's report.
City manager's report.
I lost my thing. So I don't have much to report tonight, but I think, Scott, you had something, and I believe Nancy Kay had something.
Just an informational item to let you know as of tomorrow, we will be publicly advertising our construction bid documents for the Kenema Park project. So it's going out to bid this week. Bid opening is on May 31st. And then, of course, we'll be reviewing that, and if we're prepared to do so, bring back a recommendation for approval of the contract sometime in June to the commission.
I have a question about process regarding bids for projects like this. It doesn't relate too much to the Kenema Park project, but what I saw, I've seen some emails that have been forwarded to me, and I've also seen on the Friday highlights note discussion about the design and bid letting for the work on the spray park at Carnegie. And I'm curious as to who makes final decisions on design. I would think that's a city commission decision, but this Carnegie spray park design seems to have been made without city commission input in a city commission decision, and it seems to be going out for bid without it having been reviewed and approved by the commission. And I'm just wondering, in our codes and ordinances, in these areas of artistic and aesthetic decision making, who is the ultimate authority on those?
Well, I'd have to, I guess, defer that to some of that question to our attorney. I can just tell you about the process for the spray park in particular. We did a request for proposals as a design build process. We advertised that. We put together a review committee that included staff, plus our one of our consultants who helps us did some of the the parameters of the design. It's not the design; it's a design build, so we didn't completely design it ourselves. We left some parameters open. We also asked for a representative from the McLaughlin Neighborhood Association to sit on our selection. What I can tell you on that, and then depending on the price point, whether the contract award has to come back to the commission or not. In this case, it was less than $50,000, so it didn't require commission approval. It just requires city manager approval.
That's an expenditure of funds, though. That's not a judgment upon the design merits of a project. And I don't think the two are necessarily linked. I mean, it may cost you $10,000 or $25,000, so you don't have to get city commission approval. But I guess my question is, who decides on the merits of the design? Where is the ultimate authority?
Well, I think it's multiple things. We staff just basically, do our jobs. We did take this through the Historic Review Board process, so it was publicly vetted through that process. Yeah, I did have that approval. And then it was also, there was also some planning approval that had to be done. I don't think it went to the planning commission. I think it was a staff level decision. Is that right, Tony? That sound right? So we did go through the normal processes with that. So I would say there was community participation in the approval of that. As to the, I guess we're getting into a policy type of direction that I'm not comfortable answering. I'd have to infer that to my boss.
Parks and Recreation Committee see it, I presume?
They did.
Yeah.
They did.
It seems like I recalled that there was a discussion with the commission about the spray park in particular. And there was a discussion about whether you wanted to do something bigger scope, maybe a little bit more creative, or do something more or less just repair what was there. I remember that discussion.
So there was a discussion, but that's a discussion is not that's not the same as a decision.
Well, the trigger criteria that we use, frankly, is this expenditure. I don't believe we have a design ordinance that says, I'll give you an example. There's a committee working on some art out here that's going to be displayed somewhere in the front of City Hall. And there is an adopted policy that the city has on art. And it's, how do I say this? I think it's really designed to insulate many of us from the decision about what is art and what isn't. Because that's a slippery place to be. And I think that I mean, I'll have to check with that too, because I don't know if there is a code provision that requires a review of the actual design. I mean, the same could be said, I guess, for this building when we remodeled this, although that expenditure was probably way beyond the 50,000. So the question is, for things below 50,000 that involve any kind of design element, what's the decision-making authority in the process for looking at the design? And I don't think there is a formal decision that requires, other than the money. I think the money is the trigger.
And I think Commissioner Smith just said, and I think it's correct, we gave you direction.
I think
well, it was what we took from it. And I'm not going to debate it because I don't have the minutes in front of me. But what we took from it was, okay, they don't want to do anything more expansive right now. They just want to focus. Because remember, we were concerned about it opening in time. I know that was a factor. And then there was a certain amount in the budget. And Commissioner Nocita and I have both had, he's a lot more than me, but some exposure to some of these firms like Drysaddle. You see all the creative, extremely artistic things they can do. It's pretty inspiring to see some of their work. And I think there was a good discussion here about whether or not to pursue that. And I think there were two things. There was a lack of funding, and then there was the timing issue and Scott was getting quite a bit of feedback last week when that closed, wanting to make sure it was open the next year. And that's what I recall. Yeah.
I'd like to make a suggestion in that when we talk about this community visioning project, that possibly design could be incorporated into that community visioning project as a committee or a permanent committee of that.
On the same topic, in terms of design, there may not be a time where there may not always be a time in the future or even in our path where the commission is so skilled in design as this one, but that's why.
I can attest to that because I work for some of those commissions.
You don't want the city commission making design decisions all the time because the city commission is not always going to be a good group to go to make.
Wait a minute, I think you should paint the elevator green and orange stripes.
Well, that's what paint was at one time. I mean, so I'm sure that was a staff decision.
We have people. The elevator, the whole thing, gotta be.
When it was pink, right? Do you remember when it was pink? It looks much better now. But I mean, we're all interested in design. That's why we comment on it. But that's not always the case with the people that sit up here. So I would be worried about that.
Were you wrong when I asked for the shoehorns to?
Yeah, I was sure we were going to put some more shoehorns out.
Just me.
As someone who sat up there, I think that's a really nasty, slippery slope if you want to get into the everyday design, because I would call into it, why did you let that design behind you happen? Why did you let the police put invisible logos on their car? Why did and I mean, this meeting is a work session with 3 items, and it's already gone on for 2 hours. You're at meetings till 11:30, 12 o'clock at night, and that isn't even about design. You're just talking about, do we spend $50,000 to fix the park? Not, and we'll put a nozzle here and a nozzle there. This one's a fan, and red on the west. Because at what point do you stop micromanaging? I mean, there was 2 different public committee opportunities. One was the HRB hearing, the other is the review committee, and the neighborhood was involved. They've come to us twice with it, so the neighborhood has been involved, which I think is saying that the public has been involved, and PrAC too. So you just really don't want to go there, because if you do it once, you got to do it twice. You got to, and so.
Since you brought it up, I hate the generic looking police cars.
Didn't you go to safety training, remember?
I debated saying something I just said.
I just want to add one thing is, I know on our bigger projects, parks projects, capital improvement projects, other than if it's a water line project, which people aren't particularly interested in, but anything where there's visible infrastructure, there are pretty extensive citizen involvement activities, whether it be committees, meeting with the public, meeting with stakeholders. I mean, it's pretty much ad nauseum.
Master planning.
Yeah.
For example, the Kenema project that I was telling you, I was announcing that the bids are going out. We had significant master planning.
Our advisory committees, citizen committees, neighborhood associations, CIC, and whether or not it is not in our code that the city commission approved final design on.
It wasn't in our code that the city manager's office get involved in the sewer pipe on the pedestrian bridge issue. Arguably a design issue, but self-inflicted, I might confess, to some extent. So I think a lot of this is using common sense.
Any other comments?
I have my item.
Yes, you do.
Okay. So I wanted to give the commission an update on the McLaughlin Promenade, the wall caps. As you may not know, but recently we've been doing a warranty walkthrough, and we found a series of wall caps that had an obvious defective work product. And then there were about 5 of those, and then there's about 4 that were actually damaged by another one of our contractors doing sidewalk replacement out there. And so we've asked our contractor for the promenade to replace those wall caps, and they're doing so. We're paying for the ones that the other contractor damaged, but they're responsible for the ones where there's obvious work defect. Now, we've also observed frequent chipping, and our inspectors believe there's probably vandalism is suspect in much of it, possibly from skateboard impacts. And that, to me, it's really disappointing. But I've done a complete walk through and inventory myself now too, and I'm finding that further inspection suggests that the material used for the historic preservation of the wall caps, rather than us engineers going in there and designing a really neat, super duper reinforced concrete cap, that we would have matched maybe the railing. But this historic preservation of wall caps, the material that's out there appears to be very vulnerable to chipping and erosion. So I and my department and the project team are quite concerned about the longevity of these wall caps. As I mentioned, this warranty work, if you've been out there in the last couple of days, the contractor started working on 9 wall caps, and that's underway, and the entire process takes about 1 month.
so that there'll be parts of the sidewalks that are blocked off. But in the meantime, I've initiated an investigation to closely review what's up with this wall cap material. We're reviewing the specifications, the construction field, the laboratory test results on the material, and then what we need to try to do is determine the nature of this observed behavior of the material and find out, could it have been prevented? You know, I'm never going to start finger pointing until we've done a really thorough investigation to determine whether or not it could have been avoided, it could not be avoided, and then what do we do from here? So once we've figured out what's the nature of what's causing this, I guess I'll just call it vulnerability, then we want to develop alternatives to mitigate or reduce the potential for ongoing damage. So I am absolutely positive that this is a huge concern for the community out there. It is for our department because we did the project, and I know it's for Parks and certainly for the commission as well. So we're going to be moving through this process, and then what I'd like to do is update you as information becomes available. Right now there's a lot of unknowns, but we're certainly aware that there's a fair amount of work to be done to figure out what's going on. And we don't want to leave something out there that's so vulnerable. There will be solutions that will have to be figured out, and how to solve this problem.
Thank you. That's great. I've got some questions about certainly this thing being so new, and the old one lasted a long time without these kind of problems already. And the material that's
the same material, do you know?
Oh, I don't know, because the stuff I think just fell apart.
Right. Yeah, I'm aware of that. We took several samples.
And if you'll notice, I don't know if you noticed on the back side where I don't think anybody would be skateboarding out there, there's flakes all over the place, and you can just rub your head along and it comes off.
Mm-hmm.
And then you said that we'll be paying for the part that the other contractor damaged. Why won't he be paying for that?
Well, what I'm saying is the contractor that did the promenade itself is not responsible to replace that, and we're working it out with the other contractor.
Oh, okay.
That's what I meant.
Great. Thanks.
When I walked down the promenade on I think the day we took the mill tour, and there's some on the over the wall on the wall itself. There's some graffiti in several parts. I don't know how often. I mean, most of the time we just to clean that kind of spray paint graffiti off. I mean, does that basically take someone calling in and then going? I mean, how often do we go down there and maintain things like that? I'm sure it depends on how visible it is.
Yeah,
if it's visible, we want to get it.
I think our Parks Department is out there quite a bit on the promenade doing other maintenance. If it's on the other side of the wall, we don't. We do regular inspections on the other side of the wall.
Right. A lot of the.
I got a table. No, it's the graffiti that I was noticing is down towards the VFW hall, where you can actually see, down on the wall, and there's definitely painting on there. And I don't know how long it's been there, but
I'll pass that along to our staff. So we can take a look at that.
And then one other thing that I also wanted to mention is the parking down by the VFW. That is, we're putting in some curb stops because we've also found that, that area down there, those wall caps used to be covered with like about an inch of moss. You didn't even see the surface of the concrete or whatever it is, mortar, some sort of mortar. So they've been, again, it's hard to tell, was it a skateboard, was it a car, because, but at any rate, so there's certain spaces down there that we're putting up barricades right away, and then we'll be following with installation of curb stops to stop any further of that kind of damage as well. So I think it's something that we're going to be intensely looking at and trying to figure out what the heck's going on.
One more comment. it's kind of related to that. They did that big stone wall up on top of overlooking Waterboard Park a couple years ago. And I noticed the same thing, like it was less than a year after it had been finished, all the grout and stuff seemed to be flaking out. So I don't know if it's the same people or I don't know. I thought just an observance I saw, and I thought I should tell someone at some point, but I never did until I heard this stuff. So I thought I'd mention it.
Okay, thanks, Gordon. And then regarding the skateboarders, I've already put an email to Christina Robertson Gardner to find out if we can put skateboard stops on that wall, because, you know, that's just so sad to see that damage, because we know there's some of the damages from skateboarding, obvious. So.
There's a skateboard competition on May 21st, and you can skateboard at the skate park. That's for all my students to hear.
Even when you build a nice skate park like our community did about 10 or 12 years ago, or however long it's been, folks are still going to want to try to find unique places to do that, and it's hard. We are constantly finding
nice view.
Give us the first hand.
Picnic tables, benches in parks, spray park walls, and just all kinds of places. It's a battle. It's a constant battle.
The EP decking on the steps on the Willamette Terrace was so beautiful. And then we show up one morning and it's just scraped and not ruined, but our contractor came back and sanded it down, and then we had to put up the skateboard stops, which detracts from the wood itself, the beauty of the wood, but I don't think you certainly don't want to leave it exposed to that kind of damage. So what we're doing is we're tracking, we've got a catalog of photos, and we're also then attaching the photos to our drawings, so we've got a really good record of what's being observed at this time.
Well, before we leave, I wanted to comment that there was a dead deer on Main Street just this side of 205. I reported as soon as the city office opened on Monday, and it was gone within minutes. So
that came across on the things to do for that day. Is this question time? David, I got your email about the audit on the Willamette Falls television, and I just don't understand why they haven't completed the audit yet, and we're still letting them operate and all that kind of stuff.
Well, they just to refresh, you might have, I don't know if you saw my other email, but I forwarded an email earlier that they were going to reopen under the condition that the City of West Linn Finance Department was going to be managing all their funds.
Right.
And so that was to, I think, a decision that the cities made together based upon the needs and the services that Willamette Falls was providing. But I'm not surprised that the audit isn't done yet. It usually takes a little while. And I think that's another reason they thought, well, we're going to have to be closed for 3 weeks or a month. Is there a way we can reopen as long as our finances are under somebody else's management? And that was the principal concern that we had. So I think we may have a preliminary report within a week or so. That's kind of what I'm thinking. And then just this afternoon, I sent you copies of an ordinance that the City of West Linn is proposing to change the IGA to really empower the cities to better manage the facility. So that's probably waiting in your inbox when you get home. And I think West Linn is a little bit ahead of us on that.
Did they not act on Monday? Or?
No, they didn't get to it. Apparently they had a really crowded agenda and they didn't get to it. I got a message late this afternoon that they didn't get to it, but it's on their next agenda.
That's probably just as well, so we have a chance to look at it before they take action.
And when you're in an IGA like this with a partner, you know, and they're going to take the initial action, their action is not effective unless you concur with it. So it doesn't really matter who goes first. They just happen to have room on their agenda, and their city attorney had already invested time in the ordinance change. So you'll see that in your inbox, and then you'll probably see an ordinance very similar to that they passed that will end up on your agenda.
Thanks.
But as soon as I hear the audit results, I'll make sure I share those with you.
Thank you.
Okay, so good as ever. If not, study session will